Welcome everybody. As usual, I'd like to start off by noting that the meeting tonight is being video recorded. Steve Altenberg has a small camera up on the mailboxes there, and Tony Secora has his iPad going. So these are being video recorded. Again, I want to welcome everybody. A special welcome to Mitch Brunfeld, our investigative attorney who will speak tonight, and also Greg Buckley, who's on our Budget and Finance Committee, and will speak if necessary regarding a resolution. That's point number 4 on the agenda. Dan, would you take roll call?
Abrahamson?
Here.
Gildo? Here. Pringsted?
Here.
Marla?
Here.
Check. Here.
Thank you. Is there a motion to accept the agenda?
So moved.
Second.
Okay. No discussion, we can't really change it, so all in favor say aye.
Aye.
I was an aye. Opposed? Unanimous. We have one person on the public input list. Dale, did you want to wait unless if there's questions during point agenda item number 8? So then we'll call him at that time. Okay. Thank you. Okay, number 4 on the agenda is resolution for a grant application. Ann, do you want to describe, do you want to talk about that, or should I?
I think that's why we have right here.
Okay.
Isn't that what that one is?
Okay.
Okay,
Very briefly, the reason for this, I think that the entire council is aware of this. Later in the agenda, we have agenda item to approve payment number 4 to Nordic Group, and to be able to pay that large $449,000 payment, we need to have a gap funding loan. And Greg, I think there's a term for it. It's something having to do with municipal.
Yes, it's specifically for grant anticipations where the invoices need to be paid before the grant will submit payment for reimbursement. So this facility specifically bridges that gap between payment and reimbursement.
And we appreciate Franzen Bank for stepping up to help us through this. So the resolution, and Ann, I was going to ask you this before the meeting, but resolution 2019, is there a number, or is that assigned after?
I don't know how many resolutions the city has done
Okay.
up to this point.
Okay.
But, it usually start each year with a 1,
Right.
2, 3, so I'll have to research that a little bit more. And, but have you, any of you remember any resolutions that have come before you since January?
We'll research that afterwards.
Okay.
So this is going to be resolution number 2019 dash, and there will be a number that will follow it, and it'll be the correct number. So the resolution is authorizing the issuance, sale, and delivery of $500,000 taxable grant anticipation note. It's a series 2019A. And Greg, would you like to say anything more about this particular instrument?
It's a taxable note, and it has to mature by December 31st, so it's all in accordance with the city ordinances that they allow.
We anticipate this will be a very quick turnaround, and will be paid back in full as soon as we get reimbursement following payment of the Nordic Group invoices.
Correct.
Okay, so is there a motion to accept?
Move to accept.
Is there a second? And discussion or questions? All in favor, say aye.
Aye.
Opposed? Unanimously accepted. Attorney Mitch Brunfeld is here at our request to address issue number 5. It's a mediation recommendation, specifically dealing with the separation agreement and general release of all claims between former city clerk Linda Keith and the city of Tower. And Mitch, can I just turn it right over to you?
Sure, yeah, Mayor and Council.
All right, so this council had commissioned me to conduct an investigation regarding various allegations involving your clerk treasurer. As part of, kind of intertwined with that investigation, there were some pending underlying grievance matters going on. So when this kind of got started early on, back some time ago, the union, Ms. Keith's union, had filed some grievances challenging various things that the city had done, and those grievances were going through the normal grievance process. And so that was kind of going on as I was going through and doing my investigation. My investigation involved, reviewing numerous documents, interviewing various witnesses, including interviewing Ms. Keith. What happened was that things kind of coalesced together as far as timing. So I had just wrapped up basically the work of my investigation. I was in the process of putting together my investigative report. Right around that time, obviously, we learned last week that the St. Louis County Attorney's Office had brought a criminal complaint against Ms. Keith. And what we had done was, with the grievances that were pending, one in particular, had moved through the grievance process to the point where that grievance was at what's called the mediation step of the grievance procedure. So Ms. Keith is covered by a collective bargaining agreement between this city and her union, which is the Teamsters Union. And that union had brought a grievance on her behalf. That grievance had gone through the steps of the grievance procedure, and it was at the mediation step. So what we had done, I was kind of, since this is all intertwined with the investigation, I had been in contact with the Teamsters business agent, and we had coordinated for a grievance mediation to occur last Wednesday. So what is grievance mediation? Grievance mediation is when there is a pending grievance, the parties can utilize the services of the Bureau of Mediation Services. So the Bureau of Mediation Services is a state agency. I think it's actually the smallest agency in state government. It's a very tiny agency. We call it Bureau of Mediation Services, and their job is they have a staff of very, very skilled mediators who basically go across the state and they mediate all sorts of public sector labor management, grievances, contract negotiations. So they really are the agency in the state that is primarily responsible for overseeing public sector labor management relations. And they offer mediation services. So these are actual state employees, highly skilled mediators who have considerable expertise in all sorts of labor management issues, employee issues, employment grievance types of issues. So and this is a free service, so we had decided, well, let's go ahead and have this staff mediator from the BMS come up and conduct a grievance mediation. So this was scheduled for last Wednesday, and the timing actually worked out well because, again, we had the criminal complaint that was issued by the St. Louis County Attorney's Office. I had wrapped up my investigation, was in the process of conducting or issuing my investigative report, and then we ended up in this mediation with this mediator from the BMS. And so, again, these are just very highly skilled mediators who work very well with parties in this type of a situation to try to facilitate a resolution. Now, again, mediators don't have any decision-making power. Mediators just basically serve as a facilitator, especially in a situation like this where, this was a very polarized situation. Obviously, this is a very controversial, very polarized situation. And the mediator came in and looked at it, and basically through his efforts, we were able to negotiate. I think we were in negotiations probably through the mediator, maybe 4 or 5 hours that day. We had a committee here made up of myself, Ann Lampa, Mayor Kringstead, and Councilor Beldo, and that was the committee that worked on this. And through that effort, we were able to reach a comprehensive settlement of Ms. Keith's employment situation with the city of Towers. So that's what The end result of that mediated effort is the document you have in front of you here, which is a separation agreement and general release of claims. So, so that's kind of that's the process that led up to this document that's in front of you. This is a public document. You know, the council will be considering this tonight for possible approval. And so why would we do this? We have a separation agreement, document in place that provides for a severing of Ms. Keith's employment relationship with the city. Basically, the way these separation agreements work is that the parties agree to part ways on amicable terms. So the basic way these work is that the employer would pay something to the employee that the city is not necessarily obligated to pay her. It's a separation pay. The employee agrees to resign her employment from the city. The employee gives up any and all future employment rights with the city, so it is a permanent separation of the employer-employee relationship. And in exchange, the employee also gives the city a blanket release and waiver of any and all claims. The employee and her union drop all grievance challenges. So it's basically a comprehensive settlement to resolve all issues. So under the circumstances that I identified earlier, where we have this investigation going on, we have a criminal complaint that's issued by the St. Louis County Attorney's Office, you know, some might ask, well, why would we enter into a separation agreement like this? Why would the city pay money to do this? And it's actually quite simple. This is an economic decision. So I've been a public sector labor lawyer for about 25 years. I started out early in my career as a union side labor attorney, and for most of my career I've represented cities and school districts and labor management relations in the public sector. And here's the way this works, and I think this was brought up in discussions previously in these council meetings, and that is, if you were to move ahead with a termination decision, as I indicated, this has been a highly polarized situation. If the council had gone ahead with a decision to terminate Ms. Keith's employment, you actually don't make that final decision on whether her employment is terminated or not. Because under the collective bargaining agreement, a termination decision is governed by what's called the just cause standard. So in the contract, there is a provision that says the employer cannot discipline or terminate the employee unless the employer has just cause to do so. And if the employee and the union do not believe that the employer had just cause for termination, they can file a grievance challenging the termination decision. They can pursue that grievance through the grievance procedure, and ultimately that grievance procedure ends in what's called binding arbitration. So if the union wanted, on Ms. Keith's behalf, they could take that grievance all the way to arbitration, and you would have to present your case in front of an arbitrator. This is a labor arbitrator. The State Bureau of Mediation Services maintains a roster of arbitrators. These are typically retired law professors, retired judges, retired labor attorneys who sit as arbitrators, and they will listen to all the evidence, and then the arbitrator makes the final decision on whether the termination decision is upheld or whether it's reversed and the employee is reinstated to her job. So at that arbitration case, you know, the employer has to come in and you put your case on, and you hope for the best. And I explained this to the committee when we were in the negotiation process. There's no guaranteed outcome. Even in situations like this, there is no guaranteed outcome in front of an arbitrator. I've had cases where I've represented parties in arbitration. I've had cases that I thought I was gonna win, that I've lost. I've had cases that I thought I was gonna lose, that I've won. So when you put the decision into the hands of a third party called a labor arbitrator, and he makes the final decision on the termination, there's no guaranteed outcome. And it is an expensive process. So looking at all the underlying facts and circumstances of this case, and having done this for 25 years, I predict that it would cost the city in legal fees and arbitrators' fees, because the way it works is the arbitrator charges fees for their time and their services, and the city's responsible for paying one half of those fees, and the union's responsible for paying the other half of the arbitrator's fees and expenses. And then you have to pay your own lawyer, you have to hire a labor attorney to go ahead and present your case at arbitration, because it is a very complex process. You need to put on a strong case, you need to put on an effective case. So the projected expense to the city to put on an arbitration case or to go through an arbitration proceeding, I estimated would be about $20,000 to $25,000. So in the end, if you had terminated Ms. Keith's employment and she agreed it and went all the way to arbitration, the legal bill you'd be looking at would be $20,000 to $25,000 and no guaranteed outcome. Because again, it's up to the arbitrator. There might be certain things the arbitrator might look at. You could very well win the case, but there's also a chance that for one reason or another, maybe the arbitrator says, no, I don't think there was quite enough here to terminate the employee, and I'm gonna put the employee back to work. So you spend $20,000 to $25,000 going through an arbitration, no guaranteed outcome. That's why we do separation agreements, and this is something that was explained in detail by the mediator. So if you take the $20,000 to $25,000 and you allocate that towards a buyout, and you get an agreement like this that's a permanent severing of the employment relationship, you put the money in a buyout as opposed to an arbitration case, you get a guaranteed outcome. So it's a clean break, it's a clean severing of the employer-employee relationship, the employer resigns. Yes, you are paying some money, but you're getting a guaranteed outcome for it. And in exchange, you're also getting all grievances are dropped and everybody moves on with their lives. So there is a real, there's a real benefit to doing it this way. An arbitration process is an extremely difficult process. It's expensive. It is, I think a kind of turmoil kind of is kept alive. It takes a lot of staff resources and city council resources to put on a case. So it's not only just the out-of-pocket expenditures for an arbitrator and an attorney, but there's a lot of other intangible time, effort, and energy that goes into arbitrating the case, and you don't get a guaranteed outcome. So here you funnel that money, or you put that money, you route that money into this type of an agreement, and you get a guaranteed result. So that's why we do this. This is actually very common in situations like this. It is very common for parties to resolve their differences with this type of an agreement that both parties sign, and they move on and part ways. So that's kind of why we do this. And I understand oftentimes you look at this and and that's something we talked about when we were at mediation. Sometimes there's principles on both sides of the case, right? There's on both sides of the case, people feel they have strong feelings. There's a lot of emotions involved. People feel very principled about certain things. But what the mediator does is he basically gets you back down to the economics of what you're doing here. So when we do these, I typically, I've been through these with many clients in many different situations. What I typically advise clients is this is an economic decision and it's a good business decision. And it allows the parties to go on and move on with business and move on with their lives. One other thing too to consider when you evaluate this and you're considering it for action tonight, one other thing to consider is this, is that, again, putting a termination hypothetical on the floor, if you had gone ahead with a termination, they grieved it was going to an arbitration process, that grievance procedure and arbitration process probably would take 6 to 12 months before that process was completely resolved with a final binding decision by an arbitrator. And in the meantime, you're kind of stalled out at that point, because you can't really move on as a city, because for example, can you hire a new clerk treasurer and move on? It would be very difficult to do that, because as long as that grievance is pending out there for an eventual final binding decision by an arbitrator, again, what if? What if an arbitrator for some reason decided, to reverse the termination decision and reinstate her to her employment, it would be very difficult for you in that 6 to 12 month period to hire anybody, because there's still the lingering possibility that the arbitrator could reinstate the former employee back into her position as court treasurer. So that's another factor as to why we do these types of things, because it allows the city to move on and move on with hiring, you know, a new manager and moving forward with the city business. Let's see, so as far as the couple other things I wanted to cover with you, does everybody understand kind of the just cause concept in the grievance procedure? Is that clear? Okay. As far as what her appeal rights would have been in a termination situation. Another thing is, some might ask when they look at this, why the paid administrative leave until August 31st? You know, that would be one question people might have, and here's why. These separation agreements are very technical as far as how we frame up the release language. So, in order to have valid releases under the provisions of certain federal laws and under the provisions of certain state laws, federal employment laws and state employment laws, in order for an employee to give a valid release of claims under those federal and state laws, there's certain things, there's certain technical language that has to be written into the separation agreement and release. One of which is, if you look at page 4, section 6, it's a 21-day time period to consider the agreement. Again, for there to be a valid release, for the employee to give a valid release of claims in favor of the city, the law requires that the employee has to have been given at least 21 days to consider this agreement before signing it. Now, the employee does not have to take the full 21 days, but they have the right to have at least 21 days to consider the agreement before signing it. So that has to be written in. So when we get into the timing of when does the employee actually separate from employment and when do you pay the money, it gets a little bit, the timing gets a little bit complicated, because she technically has a 21-day period in which to consider the agreement. Now, I will tell you that she actually has signed the agreement already. Again, we have to have the language in there that she technically could have had 21 days to consider it before signing it. And so that pushes the time frame out of when the agreement actually goes into effect. So that's one provision. The other provision is in bottom of page 3, top of page 4, it's section 5, what we call a rescission period. So here again, under state law, for an employee to give a valid release of claims under state employment laws, the employee has to be given what's called a rescission period. That means that from the date she signs this settlement agreement and release of claims, she has a period of time in which to change her mind. So that's 15 days. So from the date she signs, she actually has 15 days to rescind her signature and to rescind the agreement. In other words, to change her mind and rescind, and then the agreement at that point would be null and void. So in all the years I've been doing this, I've never actually had that happen where an employee rescinded, but that is a period of time or right that they have that has to be written into the agreement. So because of the 21 days and the 15 days, when we structured this and worked with the facilitative assistance of the mediator and structured this, that's the primary reason why we push the effective date of her resignation out to August 31st, because of those time periods that by law have to be written into the agreement. So I wanted to cover that point with you. The other thing to consider too is in these situations, what's kind of typical or what's the standard as far as what you see for an actual severance amount? With a lot of public sector management level positions, when you look at people who hold management level positions in cities, whether it be a city manager, a city clerk treasurer, or in school districts, whether if it's some sort of a management level position in a school district, in public sector entities up here, and I would say it's pretty typical across Minnesota, the standard separation amount you typically see is about 6 months. So when things like this happen, when parties get embroiled in some sort of a controversy or there's a, you know, a dispute over an employment relationship, and there is gonna be a buyout of a management level person in a public sector entity, the 6 months is pretty standard. And I think if you look at the economics, if you look at the numbers here, it equates to roughly 6 months of severance. And that's pretty typical. In fact, now she's covered by a collective bargaining agreement. Some clerk treasurers and city administrators or city managers don't have collective bargaining agreements, rather they have individual employment contracts. It's also pretty common with city managers or city clerk treasurers where they would have an individual employment contract, not necessarily a collective bargaining agreement. And if you look at those types of individual agreements, a lot of those actually have written into them, actually right into the contract, they have a 6-month severance language right into the contract. So the 6 months here, the numbers that we're looking at would be pretty typical of what you would see for this type of a buyout package. So that's it. Kind of to summarize, this is a mutually agreed upon document, so the employee has signed it. We reached this agreement with the facilitative assistance of this mediator. The agreement that we reached, the tentative agreement that we reached at the mediation, of course, is subject to final approval by you, the city council. What is standard practice when you reach a tentative mediated settlement of something of this nature, it's agreed upon that the committee who worked on this at the mediation would bring it forward to the city council with our recommendation that it should go forward and be approved. So that is the recommendation. I speak on behalf of the committee because we were all there, and that is the consensus of our committee, is we bring it to you as the full council with a recommendation that this should be approved. This is the most efficient way to resolve a difficult situation like this. So that's any questions.
I do have, probably one more. So, I don't know if it's 6 weeks or 2 months that she's been on paid leave, is that factoring in at all?
No, that's not credited
It's like
towards
8
the-
months.
Right.
Okay.
That is not credited towards the final amount.
To go into discussion now, we really need a motion to accept, and
Motion.
support.
I'll second that.
Okay.
And it should just, the minutes should reflect the motion to approve and authorize signatures.
Yeah. And that is the motion. Is there any discussion?
No, just feelings. I mean, I understand what you've come up with, but, I mean, it feels a little bit like, I don't know, we just don't really have a choice if we wanna move on in the city economically. And from the principal standpoint, I'd be one who would be, you know, wanting to stand on principle. There's, this is a little bit hard to, move forward. In part, I have a lot of people stopping me in the street saying, why are you paying her? Why is she getting anything? Why are you rewarding her with, well, they don't know how much it was, and fight's not the right word, but, there is a principle to fight for here, which is, some of the things that have happened. So, I guess I just am voicing that this is a difficult thing to move forward with, but I don't feel like, from what you've said, I agree, this is the way we have to go, and, but doesn't feel good.
And Mary, I completely agree, having been present at mediation, I hear you, I share those feelings and I agree with you. And it is a tough pill to swallow, on principle. And so I think we feel that.
very well in the arbitration. We need to move on.
I think Mitch explained it very well. I share your feeling, and the same with Rachel. But this comes down to both an economic decision, and I personally, I feel that it's even more important that we can move on with things, because
Yeah.
there's a lot of work to do. There's a lot of follow-up that we need to do, as the council is well aware of, that we need to correct. So the sooner we're on the road to making that happen, the better off we are. So I appreciate your comments, and thank you. Is there any further discussion?
One other thing I do want to point out is that there is no connection between, this is a civil matter, another what we call a civil matter. This is a dispute, an employment dispute, a labor dispute that we're settling with this agreement. This has no relation to what happens in the case that's been brought by the county attorney's office. That's separate and distinct. That will go forward in that normal process. And this is completely separate and distinct from that. So I just want people to understand that this resolves only the employer-employee relationship. It's a clean separation, but has nothing to do with what happens on the other case that was started early last week. So people understand that.
Yeah, thank you very much for making that point. If there's no further discussion, I'll call for a vote. All in favor of acceptance of the separation agreement and general release of all claims, say aye.
Aye.
Opposed? Okay, it passes unanimously.
You just stick around. Sorry, you need me to stick around for that?
Need a second?
Yeah.
Just kidding.
Okay.
I'm happy to if you want, but it's up to you.
No, I think that we're past that issue.
It's public document, so you can do it. Yep, yep.
So, Mitch, good explanation, thank you very much. Thank you for your assistance, very professional, every step of the way. And very good guidance for those of us that were dealing with this directly. And I think I can say that on behalf of the council. Thank you very
Yeah,
much.
good luck to everybody. Thank you.
Okay, then we'll move on to number 6, Community Coaching Incorporated contract. This is a contract between the City of Tower and Nancy Larson. Her company is Community Coaching, and I think, as all of you are very well aware, she's been instrumental in pulling together the grant issues that we've had to deal with in the last several months, and also pulling together and helping us to resolve the lack of reimbursements that have occurred. And without her help, I think the city was in jeopardy of losing a great deal of money. And she's pulled all of that together with the very capable help of our interim court treasurer, Ann Lampa. Very much appreciated. And what we want to do is moving forward. So far, she's been doing this work pro bono, and we have a lot more work to do. Plus, there are more grants in the future that we are going to address, and therefore we felt that it was appropriate to have a professional agreement between us. So that's what the community coaching Nancy Larson and City of Tower agreement is all about. In the agreement, there's a proposed scope of work. The fee is $75 per hour. The hours are flexible, and she will be called upon as needed in the future. And she's very professional. I've seen her reporting work in the past, and she will give detailed reports of the hours that she's worked. And I really think, I look at this as more of an investment in Tower than an actual expense. So that's the reason for this. I would like to have a motion to accept and support, and then we can get into discussion.
I'll
support it, okay. Any discussion? All in favor, say aye.
Aye.
Opposed? Okay, that's unanimous. Well, so now we have, number 7 is the approval of payment number 4 to Nordic Group. This is the payment that I alluded to earlier. The payment, the voucher is, it's not a voucher yet, but the detail is in your packet. The total for this payment is $449,803, and it's really the bulk of the Harbor Trail project work. And this needs to be paid before we can seek reimbursement, which was the reason for the gap funding that we're getting from Friends. Is that fair explanation? So I'd like to have a motion, and then we can discuss.
I'll make that a motion to approve.
Thank you, Steve.
I'll support it.
Okay. Any discussion?
Yeah, this is the thing, we were so, like, what are we going to do? And it just seemed almost hopeless, so I really wanna thank those of you that worked on figuring out a way to get this loan, and, you know, carrying us forward. That I just commend you for that good work. I think it's probably some good one. And then I have one question here, is on the second page, there are these lighting units, and I'm not sure if those are the lamps or whatever, but I did point out, or I did, contact you, but the lights under the bridge for this project do not work. And they've been flashing on and off, and I don't think we should pay them for that until that's fixed, but, I mean, it's a minor thing, but.
Ann might be able to
Yeah.
speak to this,
Okay.
but there's several things, including a bit of erosion and part of the,
We are holding,
yeah.
retaining, so, I believe in the amount of $35,000 right now. That will not get paid until all these little
Until
things
the
are
little things are
fixed.
fixed,
Right.
okay.
Yeah, so there's a list, including
Okay.
the lights and the erosion, and, I think a couple of other things that have been, picked up. A small group of us, met with, LCCMR, last week, and we reviewed the entire, project, and including part of the project that we're not paid. And, so I think we have a pretty good understanding of, where we are on it and what needs to be done. For this, both this and the agreement that we made with Franklin Bank, I have our new Budget and Finance Committee to thank. Dan Schultz is here, and Greg Buckley was here earlier, he spoke, and he's the one that was able to put this together. Ann's been very, very deeply involved, and Nancy Larson's been involved as well, so I appreciate all of that help. Is there further discussion or questions? All in favor of making this payment, say aye.
Aye.
Opposed? Unanimous. Point number 8 is the TIDA Lampa project, and representing TIDA, I think, is Marshall Elberter. Are you going to speak to this?
Well, I can, although I think Dale was also going to speak. I can give you a little background.
Okay.
Essentially.
Can everyone hear? Okay, sorry.
Well, we had found out at the recent engineers meeting here that there had been a delay in getting things processed for the swap out of the equipment in the welding room. And in sort of getting that back on track, came up with, other delays. And obviously it's of great concern to folks with Lampa to have This was originally approved back in very early July by the city council to do this work, but then, things just didn't happen. And so, in talking to the folks from Lampa Dale, and I also talked to Garrett at Lampa today, they're very eager to get into the building. And we think this could happen. The problem is that if we work through Lency, it's going to be a substantial delay. Also, we did get a invoice, or not invoice, but an estimate for the cost of doing the work that we had talked about. And this is just the swap out of the fume extractor from the welding room. It was $115,000, which was way above, I think, what anybody had anticipated. Now, Dale had reached out to the manufacturer and found out that the equipment was much less. We did get some written quotes from them on that. The only thing that's still outstanding is what the labor will be, but I don't think that's going to be very much based on the labor estimates that we've gotten from Lency. So we believe that if we were to terminate the agreement with Lency, basically take possession of the building, that we could bring this project, to almost to completion, to the point at least where Lampa would be able to take possession of the building and move in. Dale informed me that they have at least 2 portable fume extractors, which would allow them to operate the welding room temporarily while we then go through the process of getting the equipment changed out at the welding room. And so I think this might be the best option in terms of moving forward. Now, we hope to have actual numbers for the council tonight, and I know Dale did get numbers from the company as far as the equipment cost. I think we're still waiting on a labor estimate, and once that is in, then we can make a recommendation with complete confidence of what our price would be. But it looks like it's going to come in much, much below the cost of running this through that Lency contract.
Who would do the labor, Marshall? Do you know yet, or who would do the labor of the swap?
I think you're gonna get a quote from Range Corners.
Yeah, actually, I started out talking with, is it okay if I speak?
Yes.
I started out talking with, the Donaldson manufacturing rep, which is, Pierce Arnold. They put me in touch with, the actual company, the distributor that, sold, the original equipment, and that's BNR Engineering out of Hibbing. And he said, when they first ordered this stuff, he said, I'm just amazed why they would order 3 of these. It just didn't make sense. Because they're a lot more expensive and not as good a system as the one that we want to change out. So I got the pricing and everything quoted from them today, BNR Engineering, for all of the equipment. The equipment, including an extra electrical panel, the connections and stuff to adjust to connect the, I call them snorkel arms. All of the equipment came out to $38,476 versus $69,000 or something out of the quote. He also said they would not buy back the old units, but they would help us move them. They're a distributor. He said we sell a lot of them. He said they're basically brand new. I said, well, could we get 75%? And he said, well, I'd be really surprised if we would get 75%. So he thought that was ultra conservative. So if we got 75% out of the existing units, once you subtract off the snorkel arms, the net for equipment is $13,726. So on that $13,726, the other things I still am waiting on. I was expecting a phone call before I came here, just the remaining numbers. But the electrical wiring, I took off the quote in here, which I think we could do better. That was at $55.73. And And then the labor to remove and reinstall, that would be coming from, apparently, I didn't know that, but apparently everybody up here knows it. Range Harness. From Harry. So, and then,
It's like dinner.
so then the only other thing I was gonna throw in was 10% for incidentals. And then we would need to get the concrete pad, which I'd probably just get a hold of, Rolando or Ron, and just deal with that. So it looks like with everything said and done, we'd be 25, thereabouts, but I wanna have firm numbers for the council. The other thing, like Marshall said, is we just wanna get in there. Even if we take our current portable units, I don't wanna move in until we get those other units off the ceiling, because right now they're new and unused. As soon as we start getting dust and dirt on them, it's gonna be harder to sell them. The guy said, yeah, right now, he said, they're brand new. So, he said, yeah, he said, you know, there's lots of people, he said, I think we wouldn't have too much difficulty helping you with those. So, that's what I know right now. Another day or two, I hope to have the rest of these, so, that's where we are. And that would allow us, if we could get this done, if we could get the units off the ceiling, then, and if the council was okay going this route, then we actually could get a hold of the movers and see how quickly we could get moved. And we'd be willing to do, you know, operate on a temporary basis, and then as soon as they could put the other stuff in, we could just work it out. Any questions?
Who would take the units down? The same guys
I
install it?
was,
Oh, the same ones? Okay.
Yes,
Okay.
yeah, and that's what I was waiting for. I want separate pricing for this removal and
Sure.
install.
That would just be
Because
good.
right now, they're giving me a lead time of 8 weeks on the new system, which still hasn't been ordered by SEH. So we could live with 8 weeks, but I need the other system down right away. So I need those out of there, even if it came to the point where we had to do it ourselves. I want them to be new and in new condition.
Okay, it sounds to me like, once again, this cooperating closely with our own, governmental unit here, the Tower Economic Development Authority, has come up with a good solution, so that's the way we like to see things happen. Very good, Dale, and thanks also to TITA. Now, I don't recall, was this approved by TITA? Are we looking for approval by the council to go ahead with this approach?
What we had done was actually give authority to a committee of three to research this and make a recommendation to the council, since we would like to get this resolved before the next scheduled TITA meeting.
Okay, so this is the recommendation?
Yes,
Okay.
and assuming we can get the final numbers from Dale, I think our plan at this point would be to get this back to the council for your next meeting on the 12th. And then we can get this thing moving forward.
And if you could make sure that we have this on the agenda for the 12th, week from today. Excellent. So this was informational. Very
Oh, this
good.
is, you know,
Yeah.
so you'll have a written.
Yeah.
We had hoped to have it all done, but
Oh,
we didn't get
gotcha.
all the final numbers.
Yeah, it's just because we had a discussion about getting written things.
Yeah, so we had to get it on this meeting agenda in case we were.
Okay.
Good work, Dale. Thank you very much. So, that concludes our agenda. Is there a motion to adjourn?
So move.